What we did is we put out a Facebook post and asked the public to ask a lawyer a question so everybody could submit something.
Have you ever represented a client where privately you disagreed with their position?
The answer is yeah.
Feel in general the law protects, because sometimes I feel like maybe there's a decision has to be made because the law says this is the way it has to be.
A judge is supposed to make the right decision and follow the law.
When an unmarried woman passes, does her debt get passed to her children?
Just like what you said, I've seen that happen, where the mom just has to bite her tongue and the kids figure it out in the end.
Yes, we could appeal them, but then again, we're talking about costs,
Yeah.
expense, and all those other things.
What advice would you give a parent going through a custody battle?
Yeah. And it's important to say a will does not avoid probate.
What is the average cost of having an attorney write up a will?
Depending upon what they have to do it themselves. Two things that change people: death and money.
So I always say it's setting your family up for success. It's not necessarily setting your death date. Death and money is where conflict takes place. And like my dad always says, he's not going to do a will because you three fought while I was here, so why do I care what you do after?
On today's podcast, we talk with attorneys Scott Berry and Miranda Janssen, and we answer the questions that you submitted to them about things like wills and trusts. What's the difference between the two of them? What does it mean to go into probate? We also talked about child custody and divorce and many other things that they specialize in. You won't want to miss it.
Welcome to the Princeton Podcast, your go-to source for everything happening in and around Princeton. Join your hosts, Zach, Mary, and Kim, three locals who live and work right here in Princeton, as we bring you the latest events, exclusive interviews with local businesses, and stories that make our town special. Your community, your stories, your podcast.
So we asked the public questions for Miranda and Scott specifically, where they were able to give questions back to Kim, and we have all those questions that we're ready to ask you. But first, we would like to have you each take a few minutes to introduce yourselves and what kind of practice you do and how you got into it and just kind of your background.
You can go first.
Okay, all right. My name's Scott Berry, and I have been practicing now for 25 years. A little bit about what happened and where I came from. I really wanted to be an elementary school teacher. So when I went to college, that was my plan. I had and where I got that is I had a swimming lesson business out of my backyard where I grew up over in Wyoming, Forest Lake area.
Yeah.
And I absolutely loved kids. Loved seeing, swimming lessons is always all about teaching confidence. I wasn't really good at strokes myself, but I was able to teach the kids confidence. And it was so cool, and I loved interacting with them and teaching them and doing that stuff. So I went to college with that idea, and then I turned to the dark side. I took a First Amendment speech class, absolutely fell in love with the law, went to University of Minnesota Morris, and it was it was fun. It was a fun First Amendment speech class, and it just made me fall in love with the law.
Was that just like a general class that you had to take?
It was I think we had to take a speech class, and so it was one of those generals that just happened to be,
See, kids, that's why we have general electives, even though everyone hates them.
Oh, it was fantastic. So I took that and fell in love and decided I'm going to go to law school, and in a million years, I never thought that's what I would want to do. Went to William Mitchell, back before it was, you went to Mitchell Hamlin, right?
I went to St. Thomas, but Hamlin for my undergrad, yeah.
Okay, yeah, so it was before Mitchell changed, but graduated there, and then I got a job up in Cambridge, up near Miranda, where she's at now, and decided that I was smarter than the attorneys that I became partners with and wanted to go out on my own. What I learned from that is, at that point, that was back in 2005, that wasn't necessarily I wasn't smarter than the people that I was working with. I needed to learn a lot more, and I think over the last 25 years, I have done that. We found a house here in Princeton back in 2001, and we have 5 kids, and because of those 5 kids and the Princeton community and being part of this area and the school, I wanted to open up a firm here to be local, to really be in the community, because I absolutely adore and love this community.
And there was nothing like that.
No.
Yeah, in the community.
Yeah, it was just a great opportunity to do that. So back in 2005, that's when we opened the doors here and did that, and it's just been really honestly a ginormous blessing to have the opportunity to be here and practice and be in Princeton.
Have you always been on Rum River Drive in the old
So we
City Hall, I guess.
No, we started out over next to Pizza Barn.
Oh, that's right.
Yep, right between
Okay.
Pizza Barn and Sherburne State Bank.
Yes. Okay, that's right.
Yep. And we started there, and we used to go daily, several times a day, over to Pizza Barn, and they would give me a never-ending cup of Pepsi every day. And Bridget was there then, and
Yep.
she would allow it. We'd go in there and visit, and it was really fun. It
Yeah.
was really a ton of fun. And then we were able to move. We went from 800 square feet and moved over to the old City Hall, which is 5,000 square feet, which
Okay.
was that was really an eye opener.
Yeah.
I mean, because we used to be all really close, and you're able to yell to the other office,
Yeah.
right? Or not even yell, you just talk and.
Yeah.
And so when
But
we moved,
collaborate a lot.
yeah, oh
Uh-huh.
my gosh! And so when we moved to the new one, it was another learning curve there
Right.
because trying to communicate and make all that work. But it's worked out really well. It's a great spot for us. We've done some improvements to the office and stuff to the interior. We have to get some things done to the exterior, and that's kind of the plan here in the next couple of years. But yeah, love Princeton. Love it. We've just a great opportunity. The mass majority of our firm is family law. We do 60 to 65% of our work is in the family divorces and child custody and those type of things.
Okay.
And that was not something that again, going back to, I swore when I started first practicing, I was never going to do family law. And I was proud that I was never going to do family law. And then I had a paralegal who was with me, left, was with me, left, and now is back. Allison, who's phenomenal.
She's back?
She's back.
Oh, okay.
She's incredible. Absolutely just, yeah, very good friend also. And she got us kind of going into family law, which is, again, something I never thought I would do. Love family law. I think it's really, it's a rewarding area. And it's really interesting to say that, but it is one of those pieces that I absolutely adore. And there's a lot of attorneys out there, and I know you've practiced a lot of attorneys that they hate their job. They hate doing the family law stuff. They kind of got stuck in there. And I think it was lucky for me because it was the other way around, where we found it and determined that this is an area that we really, really enjoy practicing in.
Wow. I mean, and that's good because it's needed, you know, and the fact that you really feel fulfilled with it, because that is kind of unusual. You would think that would maybe make you cynical or, so that's great.
Yeah, you talk about it being fulfilling. Like I can see you going through the process with your clients and making it as good as it can be.
Yeah.
Which would be rewarding.
Oh, absolutely.
Yeah.
I think one of the big things, and I'm sure Miranda has seen it too, is when you start working with a client when they're going through that process at the beginning, and then seeing what's happened at the end.
Yeah.
Right? And the physical transformation that you see is just, I can't even explain it. It's it's just absolutely incredible.
Yeah.
So, yeah.
Very cool.
So we do that, and then the other part is we do a lot of wills and trusts, do civil litigation, and a lot of real estate work. So those are kind of the areas that we practice in. And it's interesting because the wills and trust and the real estate work and the civil litigation was all stuff that I did before, pre-family.
Right.
Yeah.
But a lot of that also works back into family. I think that's the other interesting thing is the family law cases are all so different. Yeah, and they involve everything because you kind of have to have that knowledge base with all those other things. So.
Yeah, because I guess you just really think family law, divorce, and so it just, but it involves a lot of different things.
Oh,
Yeah. Yeah.
So it's interesting, and it's very. Miranda and I were talking about it before, and I think it's also a very hard area because it is, the judges have so much discretion.
Right.
In other areas, the law is what the law is. You got the statutes, you got the case law, and in family law, it's very discretionary in what the judges are able to, the decisions they're able to make, which makes it many times challenging. So,
But also something different every time. I mean, that kind of makes a job fun too, when it's not always the same monotonous thing day after day after day.
Yeah.
A different challenge and keep your mind fresh on how you're going to approach things. And yeah,
yeah, absolutely.
awesome.
Absolutely.
Good. All right, Miranda, how about you?
So I graduated Princeton in 2016 and knew that I wasn't going to leave the area. Good family and friend base around here. So I went to Hamlin for my undergrad and participated in track my first year, lived at home my second and third year, graduated early and went to St. Thomas. And when I started my undergrad, I thought I was going to do like criminal psychology, like understanding the minds of like serial killers.
Wow.
And I knew that I didn't want to be in policing. I had reserved for the Princeton Police Department and knew that I just didn't want to be boots on the ground. But that was really eye-opening because then after doing psychology classes and knowing that I didn't want to read books the rest of my life, I transitioned into like a legal studies field and then started law school only to end up reading for the rest of my life.
Yeah.
So that was a bit of an eye-opener. And I think the cool thing from like transitioning is every case has its own facts and it can be interpreted in so many different ways with the law. So after law school, I started prosecuting right away. In law school, I did all criminal defense work. After graduating, I knew that I wanted to be a prosecutor. And having that police reserve background, like I was actually able to understand a case from the beginning to the end. So I started over in Meeker County for about 6 months. They took me on before I had my ethics board license. So I wasn't fully licensed when I started there. And they really taught me about writing complaints and understanding what we need to prosecute and the elements that we need to meet before we can charge someone out. And then I took a job with Isanti County where I had interned my last year of law school and moved into the felony division there, handling all types of felony cases. That started dwindling down to specializing. So I specialized in the victim-related crimes, specifically like domestic violence, strangulation, and child criminal sexual conduct cases. And then I took a job over in Benton County for my last year and only specialized in those cases.
Wow.
And that was really rewarding. I definitely missed prosecution. After I left Benton County, I took a position with Sapientia Law Group, formerly known as McInnes and Doom over in Cambridge. And I had mentored a little bit with Sherwood McInnes when I was in Isanti County. We had some cases together and just really saw a lot of wisdom behind Sherwood and a very eloquent way of speaking to people and relating to people. And each of my cases, or each of my different counties that I worked for, fantastic people working with, but I always felt like I was like lacking additional knowledge, additional resources. I like to push the bounds when it comes to cases. I like to, if I know we can win a case, if it's not going to result in a plea deal that I think is sufficient or the victim thinks is sufficient, I was willing to take it to trial, and had a really good success record in trials. And so that made me approachable for entering civil practice in the litigation area. So about 25% of my practice is family law. And then I deal with civil litigation, usually plaintiff side. We do a lot of data privacy cases, employment matters, some business litigation behind there. I do corporate formations, some wills and estates. And then I feel like I'm missing something. Our firm itself does a lot of bankruptcy, and then I do some criminal defense work. DWIs is kind of where I sit. But
You're talking about some of the business corporation stuff too?
Yeah, business corporations, so startup businesses. And I think that's the area that I'd really like to hone into outside of family law, just because coming from Princeton, like everybody is a small business, and I love supporting the idea of keeping businesses afloat in their hometowns. So working with them from the start of their business corporation to how do we deal with tax issues, how do we work with hiring and firing employees, terminating contracts, things like that, getting money back for people who have done a job and aren't getting paid by the people who hired them. And then I've dabbled a little bit in banking litigation with Sherwood McInnes, doing like foreclosures or getting money back on loans, things like that.
Well, and I've brought this up before on other podcasts and at the chamber about one of the small businesses in town one time mentioned that she's a speech therapist and opened her own business. And she said, that's what I'm good at. I'm a good speech therapist. Do I know all the ins and outs of running a business? No. You know, she's like, I'm trying to learn the accounting side of things and the business side of ththings. And so what you're talking about is that's a really needed thing,
Yeah.
you know, for small businesses because they have their specialty, which is what their focus is on. But there is a lot of other things that you have to do within the business.
Yeah. Well, and the best part I think about having kind of this business law background is working with all the individuals in the community, like accountants and tax preparers and just support and mentor from other business leaders. So being able to provide my clients resources with other individuals who are going through same circumstances or need additional support in their business. I really like having that network of people that you can all just kind of rely on.
Exactly.
That's awesome.
Yeah. That's definitely a small town benefit.
Yes.
That's great. So what we did is we put out a Facebook post and asked the public to ask a lawyer a question. So everybody could submit something and they could submit just to you, you know, either one of you. Many did both. So so we have those list of questions. We got some really good ones. And we're going to jump in here. So our first question is from Miranda. And the person who submitted said, my 23-year-old son has been raising his 5-year-old son for the past few years. The mother is on drugs and is not in contact with her son. The father was living in Wisconsin, and the courts there gave him custody because she was an absent parent. But now he's living here in Minnesota again. Should he try to hire a lawyer to get full custody here, I think is what they're asking. Yeah. I'm afraid she could get custody of him at any time, even though she isn't fit.
I think the difficult part here is we have Minnesota and Wisconsin laws. He's established full custody through Wisconsin. Scott can chime in here. If I were in that position, I wouldn't get an attorney. I would continue life as is. The best interest of the children factors come in, and it sounds like he's doing a good job with his child and has that full custody at least established in Wisconsin.
So when you are given full custody, that just is in that state? I mean, that is
not necessarily.
Right.
Go ahead, Scott.
All right. Well, the full faith and credit of the United States. So the Constitution essentially says that the states have to, I don't want to say defer, but recognize orders coming from
other courts.
So like Miranda said, I think she's absolutely right, that when custody was established in Wisconsin, Minnesota, well, you want that custody order over there. You don't necessarily want to come and try to relitigate it in Minnesota.
Right.
Essentially was what she was saying. And
because you could get the opposite.
Yeah, it'll give her a bite at the apple to come back in.
Yeah, I mean, my recommendation would be exactly what she said, is I don't think he needs an attorney at this point. I think that based on if he has custody, the question a little bit is the parenting time piece. I mean, there's so much more that goes into it than just custody, because custody itself is the decision-making piece, right, as it relates to education, medical, religion, those type of things. And when you talk about parenting time, that's the actual amount of time that you actually spend with the kids. Now, different states, again, treat that so differently, you know, as it relates to custody and those type of things. So what I just said is Minnesota. But we still defer, we still recognize other states and their custody orders that are coming out.
Okay, so then you're saying, so custody really is about the decision making. That doesn't necessarily mean the other parent can't see. That would all be
Right.
And that's
a part of
something
the
that, like, when we get family law cases, like, parents are like, I want full custody, and understanding what they are asking for
and what that means.
Yeah, because a lot of the times full custody is I want my kid 100%.
Exactly.
And that's not what custody means in the legal sense.
Okay.
So we have to talk about parenting time, and even that's confusing. It used to be called visitation. And so talking about how much a parent gets parenting time, it's presumed in Minnesota 25% parenting time. And so really differentiating between the two. So in this circumstance, the dad here would have full custody, meaning the ability to make full decisions on behalf of the child. So we don't know whether mom's even seeing the child or ordered to see the child through that parenting time evaluation.
Okay. Wow. I guess, yeah, that's how I've always thought of full custody is full time, everything.
Yeah.
Yeah.
So she could come back and just ask, like, if it said that she was an absent parent, which I assume she's not part of the picture right now, but she could come back and say, I want my 25% of parenting time, whether it's supervised or not supervised. She can do that, and he still would
have
remain
full
have full custody.
He would have full custody until the order is modified.
Okay.
So anybody at any time can come back and ask, but the courts really evaluate the best interest of the children. So there's a statute that courts have to follow, and it's all 12 different factors that relate to how is the child going to benefit from having contact with both parents, or how is a child going to succeed by not having contact with both parents? What does that look like? And it wraps in custody, parenting time, medical decisions, things like that.
Yeah.
Schooling, different interpretations of what it means to have your child thrive. So any parent can come back and ask for a modification of a court order, but they have to have a substantial change in circumstance to enter into the court to do that.
Okay.
So her substantial change would likely, under this scenario, have to be that she's sober and participating in her sobriety, and is in a position where she can be a active parent. And the court then decides whether supervision or non-supervised parenting time takes place, where that takes place. A lot of different factors kind of weigh in on the court.
Do you find that this is going to be really a super subjective question, and I don't even know if you can answer it, but you hear about those cases where people are like, well, he or she, that parent, should not be allowed to see that child. That's so harmful to the child or whatever. Do you feel in general the law protects? Because sometimes I feel like maybe there's a decision has to be made because the law says this is the way it has to be. Do you feel the law most of the time is on the side of the child?
I would say almost always the law is on the side of the child. We wouldn't have those best interest factors if it wasn't. And when I get clients into my office that say, dad's going to take this child or mom's going to take this child or vice versa, I don't want them to have anything, we have to break that down with them. Like, is there domestic violence going on? Is that domestic violence happening to the child as well? Is there other abuse taking place? Is there neglect taking place? And what does that look like? We all come from very different backgrounds and have a very subjective opinion about what's happening. So we try to pull that back and make it objective and understand that just because we don't want them to have parenting time or custody, the court is presumed 25%. And it's on that other parent to show why they shouldn't get that 25%.
And they're coming in with a lot of emotions and, to be able to come back and try to just focus on the facts.
Yeah, honestly, in my cases, it's probably a month to 2 months of talking with parents before we kind of get on like an even level of like thinking rationally. But they're the ones dealing with it every day. They're the ones receiving the text messages, dropping off kids, having interactions that may not always be the best. So we have to understand where they're coming from as an outside observer. And really rationalize with them, here's what the statute says, is this in the best interest of the child? And I would say courts are they have a lot of resources, guardian ad litems, parenting consultants, to dive into cases if there is a big conflict between whether a parent should or shouldn't have parenting time.
Okay, that's a good answer.
All right, on to the next question for Scott. What is the average cost of having an attorney write up a will? Is there a huge downfall in doing it yourself? And what advantages of having it done by a professional are there?
Well, that's a really good question. Now, from our perspective, I think it really depends on the firm that you go to. Okay, we do our wills, and I guess there's a couple pieces I want to throw out there. A lot of times people could say a will, there's a misnomer or misconception that a will avoids probate. And a will does not necessarily avoid probate, and most people, that's what they want to do, is avoid probate, okay? And so the process that we bring our clients through is number one, we identify what are we looking at from an asset perspective, right? What do they have? Who do they want to leave their assets to, right?
Right.
Because that makes a difference. How do they want to leave their assets to? Sometimes they want to do it over a period of time because they're afraid that, like in Kim's example, we all know that if she got the money, she would just spend it, right?
Right. I'm out of here.
Right? But, so, your parents could set up a trust to make sure that Kim doesn't do that. Like in Mary's, we know that she's going to be very frugal and all those other things. So,
Oh my God.
I should just be
God
the,
is so opposite.
I should be the executor of the mom.
Oh yeah.
but the point
take
is
that on.
that, it really depends because you can do things to, I guess what I call is kind of parent beyond the grave. But everybody's situation is so unique. And when we look at the cost, it really depends, again, on what are all the documents that we're doing with it. Are we doing just a will? Are we doing a trust with it? And then with that said there are other documents that go along with it too. Is there a deed that we're because we're doing a trust or we're doing some kind of transfer and death piece? A lot of times people are concerned about the decision-making while they're alive, so then we're looking at power of attorneys and things. So it's kind of a sort of a moving question.
Yeah.
And my answer, as it relates to whether or not you should have a professional do it, for us, it's a free initial consult. So you come in, we chat, and once we figure out what the clients need, we give them the price, and if they decide they want to run out the door, then they have the ability to do that, and there's no obligation.
Okay.
It doesn't happen very often, but
And I would imagine that it's, like I think when I think about what I leave my kids, I'm like, I don't have anything to leave. Sorry, boys. But, that's kind of how it just feels, with your living your life and stuff. Like I don't have, but you walk through people through like
that, yep.
you have things that you don't realize that need to be dealt with,
Well, at any time that you have children, right, whether they're adult children or minor children, when you have more than one child, then there are pieces that you really have to take into account. I mean, because in my experience, and I don't know about you, Miranda, is two things that change people: death and money. And it happens all the time, and I've seen it way too often. And so as much as you can do up front before that happens, before your death, to try to make it so it's a very smooth transition, the better off it's going to be.
but it feels icky. Like I feel like I
Like you're setting yourself up.
yeah,
for
like
death.
I asked James from Williams Dingman too. It seems like it's like you're jinxing yourself.
Well, and I always let people know, like, because we do get a lot of that.
Yeah.
And kind of on Scott's point, like, death and money is where conflict takes
Yep.
place. And like my dad always says, he's not going to do a will because you three fought while I was here. So why do I care what you do after? So we're pushing to get a will done there. But to that point though, like it feels icky, one, because you're essentially planning what happens to you after.
Yeah.
But on the flip side of that, you're setting your kids up for success.
Yeah.
You want them to grieve appropriately when you pass, and whether that's your kids or your nieces and nephews, whoever is in your lineage. And so setting them up for success to understand, like, okay, I already got my finances taken care of, so you can take care of the funeral through this fund, the money goes to you in this, the house is here, and then they can grieve appropriately and kind of move forward with their life.
Because it's all taken care of.
Yeah.
Absolutely.
So I always say it's setting your family up for success. It's not necessarily setting your death date.
Right. Okay, that's a better way to think about it.
Well, and I think the other piece is, Kim, with what you were saying about, I've had clients come in and say, this was actually fun.
Oh, really? Okay.
Which always strikes me, but they've said that this is a good experience. And again, same thing. Sometimes when we're going through when I see clients go through that horrible divorce process and the transformation, same thing sometimes happens on the estate planning side. They're like, "Oh, this is great. We got this done. This is great," and
They feel good about
they
it.
feel good about it. And it's not necessarily that they set themselves up to die now. It's
Yeah.
Right.
In fact, I tell them when they leave, yes, you can go swimming with sharks.
Yeah,
and
you're okay.
Jumping out with without a parachute, but don't do it.
Don't do it. I mean, why would you?
Yeah.
Yeah.
Well, everything's all set, so.
Yeah.
But the other piece too that you got to be careful about going to whether or not you should have a professional is if you do it wrong, not only does it maybe affect the kids, but you may inadvertently result in some of the spouses sometimes creating issues, and you may actually create bigger issues. Like,
Yeah.
again, if you want to try to avoid probate and the cost of probate and doing those things, again, those are all things that need to be thought about as we're going through the process. And to be honest with you, I have told clients, depending upon what they have, to do it themselves. I mean, if we sit down and say, no, it makes more sense for you to do it yourself, go do that. It's going to be cheaper.
Okay.
So
And how do you do it yourself? You just
there's
write things down?
Well, so in Minnesota, you have to have at least 2 witnesses, okay, to a will.
Okay.
If you're going to do it yourself, I would recommend that you do some kind of online piece. But I would be very, very careful, and I would first consult someone to say, does this make sense?
Yeah.
Find out what exactly you want to accomplish.
Yeah, so if somebody did want to, like Mary was asking how to do that, can they just chat GPT it and say, make me a will?
You can. You got to be super careful because Chat GPT and some of the other AI pieces out there, they have a tendency to make stuff up. And there are a lot of attorneys, I shouldn't say a lot, but there are attorneys that are getting in trouble because some of the information or the responses that are being provided by ChatGPT and some of the other AI pieces. So you got to be super, super careful when you do that. And again, that's the reason that it's important to work with a professional.
And a human.
Yes.
Because right now I don't think AI is there yet.
Well, and I think about, how AI pulls from all these different things. Well, there's many, many Kimberly Youngs out there in the world. So who knows what would, get pulled into something that if I'm asking.
Or different states, different
or
laws,
different
everything.
Yeah, different everything.
Well, and with ChatGPT, like you're inputting what you want it to outcome. And so
Right.
with that, like when we sit down with clients, we go through every possible asset and debt. And so when you were talking about like, well, I don't have anything to leave. If you don't put that you have a house in there, they're not going to designate in the ChatGPT will or whatever AI form you're using. It's not going to output that you have a house because it might not pull that you have a deed on record somewhere.
Right.
So just thinking when we sit down with clients, really talking about, do you have a timeshare? Do you have recreational vehicles that are worth some money? Who are those getting left to? Cabins, things of that nature. Funds in different accounts. Maybe you had a pension at a job you were previously at and you forgot about it 15 years later. So really diving into the finances and making sure, one, you have beneficiaries listed for your people, but two, kind of going into that probate side of things. How do we ensure that the money's going as you intended and not falling into probate?
Can you tell us a little bit about probate? What does it exactly mean? I know you want to avoid it.
Yeah, I'll let Scott kind of talk about probate.
Yeah, well, probate is it's a court process to pass your assets from your estate when you pass to your beneficiaries, and then through that process you pay your debts and do those type of things too. It's a long process. Probate, I tell clients at minimum it's 6 to 12 months minimum amount of time to go through probate. And it's expensive and it's difficult because you not only have certain accounting things that you have to do and rules that you have to follow and publications that you have to do, but you also open up your estate to everybody in the world because it's public. And that's part of some of the estate planning stuff when we're talking about trusts and things like that. We can make it so it is private. And so you don't have to open all that up to everybody.
So probate is like once somebody passes and then the will gets read or whatever, and then there's problems, so then it goes into probate?
No, so if you just have a will, and for example, let's say, I'm going to pick on you for a second. Well, Mary, I'll pick on you since you asked the question.
Okay.
So if you have a house, right, you have real estate, and if you just had a will, then you would have to go through the probate process because you would meet if you passed, you'd meet the requirements for the house to go through or the real estate to go through probate in order to pass to your beneficiaries. Okay.
Because your beneficiaries are just named as these are my 3 beneficiaries or whatever, but not probate will decide how that is split between those 3 beneficiaries?
Well, so probate typically defers to your will. So the first thing that probate does is it needs to define your beneficiaries, right? So if you have somebody else, another child that's out there, a 4th that we didn't know about, right? It gives someone the opportunity to say, hey, I'm also a child of Mary, right?
Oh.
And so that's one of the other pieces that it does.
Okay.
The other thing it does is it gives everybody that has potential claim against the estate to submit that claim, okay? And so there's a period of time that they have to do that, all right? And then once that's happened, then the probate court identifies all the assets, identifies who are the beneficiaries of this estate, and then they say, okay, if you have a will, it usually, I say usually because I've had a couple cases that a judge is supposed to make the right decision and follow the law. And I've had cases where the judges don't follow the law, and yes, we could appeal them, but then again, we're talking about costs and expense and all those other things that go on with it. So those are all the kind of the issues with probate. Okay.
So the best way to avoid it is to really get that all in writing in your will.
Well,
and
Not necessarily. Like, so an example case, I had a client who had gone into the hospital and she had a prior will, but she wanted to adjust it because all of her assets went to her sister. She came out of the hospital. I met with her. We got the initial consult down for where she wants things to go. I'm drafting the documents for the new will, and she passes. So now the new information that she's provided me doesn't control. It's the former will.
right.
Because it wasn't done.
Yep. So especially like when you have a former will and you want to change it, I would say definitely talk to an attorney about doing that, because if it's not done properly, your old will controls.
Right.
So now the court has to deem everything under the previous will. And because the person who was appointed in the previous will has already passed, it opens it up to her lineage. So she didn't have children, so it's all the nieces and nephews and their kids from the nieces and nephews, any aunts and uncles. So now we have to go in for this probate matter and send out letters to all possible lineage. But it still allows anybody open to the public, medical providers,
Wow.
loans, things like that. And then, thankfully in this position, she didn't have outstanding debt. But anybody can come after the money if it's not designated in the will, and even if it's designated, but it kind of structures it in a way that the courts should be following the will.
I see. Okay. Wow. It's per case for sure. Yeah.
And it's important to say a will does not avoid probate.
Right.
Correct.
Yes.
So that's
I'm
the other
definitely getting
piece.
that.
Yeah.
Yeah. Yep. And every case is different too, depending on what's going on. Okay. So, is it my turn?
Yeah, for
Okay.
Miranda.
This is a kind of an interesting one. I'm not sure exactly how you're going to respond to it, but is it illegal to message someone online, you messed with the wrong family, and how should this be handled?
It's not technically illegal. We have the right to the First Amendment. On that base, though, there are potential criminal charges if it escalates. So when I was prosecuting, we would charge out what we call threats of violence. And that's a felony charge in the state of Minnesota if you threaten reckless harm on somebody or a possible assault on somebody. So if I say, Kim, I'm going to hit you, there's certain language in the statute that it either has to be in reckless disregard for your fear or sense of fear of harm, or you don't have that, and I escalate it to say, I'm coming over to your house to murder you. That can be a threats of violence if you have reasonable fear that that's actually going to take place, or I say it recklessly at a bar, in a bar fight while we're fighting, and I say I'm going to hurt you. So that language alone does not constitute for the threats of violence. If it were to escalate, it could. On the flip side of that, we have what we call an HRO, and there's HROs, OFPs, and domestic abuse no contact orders. All of those are different among the law. In this situation, if it's not a family household member or a family relationship, it would fall under the harassment restraining order.
Okay.
So reporting it to law enforcement would be step one. I would say, as somebody who worked in reserves and prosecution, I'll take your report, but there's not really anything of substance to move forward with. So it wouldn't be sent up for charging to the county attorney's office or the city attorney office. In this regard, if there's ongoing messages in a harassing context, and there's certain language in the criminal statutes that designate what harassment is, there has to be substantial emotional distress to the party, and there's different forms of harassment. So in this context, if there's additional text messages coming through, or you've asked the person to stop, or you've blocked their number, you've changed your number, those can be substantial steps that you've taken to stop the contact. And if it's continuing, then I would seek out a harassment restraining order and a possible criminal charge for harassment.
Okay.
So when you say that people can call and make a report, and the police won't necessarily do anything, or they don't have enough to do anything with that, is that somewhere Is it in a
on record?
Is that on record?
Yeah,
then?
any report that you call in, law enforcement will take it down and draft up what they call as an incident case report, so an ICR. So it'll all be tracked. So when I was working in prosecution, when we had harassment cases or stalking cases, I would literally have our victims call in to law enforcement every single time something happened. It gets really ridiculous for law enforcement having to deal with all of it. But we need to show a standard here that the contact is not stopping.
Okay.
And so when
Makes
you're
sense.
reporting it, rather than just you holding on to the text messages, it's being stored in a system with law enforcement. So when we go back and we charge out stalking, we can show that all of these police reports have been made. The other part is some people in domestic violence situations don't want to talk to law enforcement because they know that there's going to be repercussions in the home.
Right.
So saving as much as you can, providing that information to a trusted family member or friend to hold on to. A lot of times we see domestic violence partners going through the other individual's phone. So if you can save it and send it rather than storing it on your phone, that also is helpful. Something that I do in my current work as a civil practice, I work a lot with victims' rights. And so having that experience as a prosecutor walking through the criminal justice system with victims, I now, on the flip side of that, do HROs and OFPs, but we also represent victims in court to walk them through the criminal justice process. And so if there are like stalking or harassment cases, clients will send that information to me where we will store it all rather than having it on their phone.
What's OFP?
In order for protection.
Order for
And that
protection,
falls
okay.
within the family realm.
Okay.
That was some great advice.
I think one of the other pieces is that if there is a situation where there has been some kind of domestic or any kind of abuse, it's important to have a safe word.
Yep.
And have someone that you can, well, you text it to somebody or something like that so they can call law enforcement and get someone there to assist. Because, that, again, same thing that Miranda was saying is a lot of times if that's happening, you don't want to escalate that issue.
Right.
And I'll just add a piece in here. Law enforcement now has where you can text them. So
Oh,
I know
really?
that has helped a lot of victims if they're actually like in a physical altercation. Rather than getting on the phone and making things worse, they can text. So just a plug there for law
Wow,
enforcement.
that's cool. Yeah, because sometimes that could put a person in more danger trying to call 911 or whatnot.
Right.
Yeah.
Should we ask one more question and then go to a quick break?
Yeah,
Okay.
we're going to go right back to wills here with Scott. Somebody would like to know what the difference between a will and a trust is.
So that's kind of what we were talking about before with probate and probate avoidance. So a will itself will not necessarily avoid probate.
Right.
Okay. It still allows your assets, or your assets have to go through the probate process in order to pass. With a trust, provided the trust is properly set up, it can avoid the probate process. Okay. It's more of where the will and the probate is public, a trust is more of a private process that you go through.
So a lot of people then do a will and trust.
So the will and the trust they work together. Usually when I meet with clients, I have this board that I write on to kind of try to explain it.
Yeah.
Yeah, I
Yeah.
And so the trust itself, I guess the way I look at it is the trust itself is kind of a landing pad or like a file cabinet, okay? And so you put your assets into the trust or into the file cabinet for it to hold, okay? And then the will, what it does is it only comes where a trust can be while you're alive and make some decisions while you're alive as to how assets are to be held and distributed, usually for the people that created it, as well as after you pass. A will only comes into effect after you pass too.
Okay.
Okay. And so those are some big differences. The other nice thing about the trust is that while you're alive, you're able to, if you do a revocable trust, make modifications to the trust. And again, it makes, can identify how those assets are held while you're, if you become incapacitated or incompetent, the trust can say, this is how I want those assets to be held while I'm alive for my benefit.
And so can you change that, excuse me, like let's say you decide to purchase a timeshare.
Yep.
After you've done your will and trust, you can come back in and add that in there?
Yeah, and you don't necessarily even have to change the trust to add the timeshare or any other asset. A lot of times it's just how you title that asset
Okay.
into the trust.
I see. Okay.
And I would say that's kind of an important piece if you are looking at a trust to get an attorney, because
Yeah.
any asset that you pick up, you want to make it sure it's titled appropriately to fit into the trust, because if it's not at the time of your death, it falls openly to probate.
Right.
So I would say, most importantly, if you're looking at a trust, to definitely consult with legal counsel to ensure that your items, your assets are titled appropriately.
And there are some assets you don't want to title in the trust or even appoint to the trust because of the tax ramifications and
Yep.
things like that go with it.
Okay.
So it's a little bit more complicated than
Yeah,
just setting up the
professional.
trust. But I think Miranda's absolutely right from the perspective of identifying what assets go in the trust, what assets are named to the trust after you pass, and what assets shouldn't even hit the trust.
And that's why you're the experts, and the general public just doesn't know, about those things and how to do it correctly. So, good. Well, I think we're going to take a quick break, and then we'll be back with the rest of our questions. Today's sponsor is Jake's Top Notch Tree Service, and I am one of their newer customers. I had a great experience with Jake's Top Notch Tree Service when we had to have 2 trees removed. I came home from work after they'd been out. I couldn't even tell there were trees there to begin with. They are quick, they are friendly, they do a very good job. They leave the site as if they weren't even there. Jake is a great community sponsor for many different things, including this podcast and Light Up Princeton and the Rum River Festival. So we want to thank Jake's Top Notch Tree Service.
All right, and we are back. Back with some more questions. So, Scott, we'll start off with you. When an unmarried woman passes, does her debt get passed to her children? An example, credit cards, personal loans, mortgage, all that stuff.
So when a unmarried person married or unmarried person passes, the debt is, we were talking before about probate, and it gets dealt with in the probate, okay? And so the part of the purpose of probate is to take care of some of that debt, okay? And if they have assets to cover that, that's where the probate process would do that. It does not, the individual children are not individually responsible for that debt, okay? So they're not personally responsible, I should say, for that debt. So it doesn't pass down to them for that personal responsibility.
But what if this person doesn't have any assets?
Then if there are no assets, then the people, the creditors, the people that are claiming the debt are more or less out of luck.
Okay.
Is what it comes down to.
Okay.
Yep.
That is a good question, I think, for people to know.
Yeah.
I'm sure it happens.
Oh, yeah. No, it happens a lot.
Yeah.
Yeah.
Okay, Miranda. This is kind of a long question, but I do think that this is probably a pretty common question. My kids have stated that my ex-husband is pretty verbally and disrespectful regarding me on a regular basis. Our decree is verbiage that outlines we need to remain respectful to one another. I am very careful about the things I say in front of my children who are now teenagers. I'm not perfect, but it's extremely minimal. Is there a way to enforce that part of the decree?
In the context of this question, is it, just a clarification, is it that he's talking to the children about her?
Yes.
Okay. Step number 1 is to, if you guys are civil together, is to have a conversation between the two of you. Hey, I've heard that the children have said this. Can you make sure you're talking appropriately? Most decrees do have outlined that they're not supposed to talk about adult things with children. And that's just life. Like, just don't do it.
Right.
In this context, though, if it's not stopping, if there's a continued concern, talking to an attorney would be appropriate. I have a lot of people come in and say, hey, he's talking poorly, or he's saying this over our app that we use to communicate, and it's not appropriate, or he's not following the decree. So I have a lot of consultation with clients about what's ordered in the decree versus what's actually happening in real life. In that regard, if the person were to come in and talk with me, we would talk about what's being said. A lot of it is, my understanding, is coming from the children, so understanding that sometimes children lie. But in this regard, we talk about what are those statements being made. If we need to, we'd either send a letter to the opposing party, so the husband in this case, letting him know that this is the language of the decree, it's our understanding this is what's being said, and that language needs to stop unless you want further court ramifications. After that, we look at the decree. Most decrees say that if there's a need to adjust the decree, we look at mediation first. So if he decides or hires counsel, we'll send the letter to counsel noting, here's what you need to do with your client because inappropriate conversations are taking place. Sometimes it doesn't end there and they continue to bash the other parent. And so at that point, we look at changing language in the decree to no conversations about adult topics rather than no disparaging language to the children. So,
And I mean, it's just going to cost both parents more money,
it's
for
going to cost
one.
more money. If you can put up with it, great.
It's harming the children.
Yeah. One thing that I think I've learned the most from family law is when children grow up, they start to understand
Right.
what each parent is doing.
Yep.
So if it's not truly affecting a relationship with the kids, kind of brush it off for right now. See if you can continue, especially with them being teenage kids. It's not going to last forever. Hopefully you're under the 8-year line here to get out of that. But people are going to say what they want to say, and the children at the end of the day will hopefully come out on the plus side of it, understanding it's just part of the relationship, and I have a good relationship with mom, so it's not harming me at all.
And just like what you said, I've seen that happen, where the mom just has to bite her tongue and the kids figure it out in the end, even though it's really hard. Yeah.
And the best that she can do, because we also talk about like coaching with our clients, the best that she can do in this situation, if her kids are reporting back to her that this is happening, just say, okay, thanks for letting me know and move on from the conversation. Because asking questions about it isn't appropriate to ask your kids. Saying that's not true or getting into the details and the facts, that's not going to be helpful either. It's just going to cause more conflict. So, okay, thank you for letting me know and move on from it. And you can start documenting it too with the opposing party, saying so-and-so came home, Jane Doe came home and told me that this was said. Please keep contact about us to a minimum in front of the children. And sometimes too, it's just kids overhearing what the opposing party and their other significant other are talking about.
Right.
And so with a lot of my parents, if they're in a relationship with somebody else, we talk a lot about ensuring that adult conversations are taking place outside of the home and not happening in front of the children. Even if you think a conversation is not in front of the children, they're listening from the other room.
That's right.
So really ensuring that our children are set up for success, and that success means not disparaging the other parent.
Excellent.
All right. Next one is for Scott. Have you ever represented a client where privately you disagreed with their position or felt the other party had a stronger case? And if so, how do you handle that professionally?
The answer there is, well, let me back up. We try to be what we consider on the right side of cases. Okay, we really try. Are we always? No. Have we ran into, and I've been practicing 25 years, and the answer is, yeah. Have I been in a case that I feel like the other side has? Yes.
Yeah.
But we have an ethical obligation to our clients to do the best we possibly can for them. And that's what we do. I mean, that is our, is that we try to be as upfront as possible with our clients to identify what the issues are with their case, what the potential ramifications are, and how the case can go south. I mean, because I think the clients, it's extremely important that they understand what potentially could happen. And if you're not honest with them up front, that's how we typically approach it.
Okay.
Yeah.
Very good. Miranda, this last question is very general. So maybe you could give some steps you could, take at the beginning of this process, and either one of you can. But the question is, what advice would you give a parent going through a custody battle? So I don't know if they're talking like it's just about to begin, or how you want to answer that.
So there's a bunch of different contexts that sit in that. The first being if the person is going through a divorce with custody issues, or if it's no marriage but they had a child. Those are kind of the two scenarios that we see. In those scenarios, we see hostility versus people are in agreement. So those cases vary drastically in the amount of touch points, is what I call it, how many contacts I have into the case. So like if Scott and I were to work on a case together where there's custody issues involved, typically what I do with my client is we sit down with kind of our initial consult, talk about what the situation is. If it's a divorce, we fill out certain questionnaires related to the divorce, and then we talk about the children. If there's not a divorce, those questions are just off to the side. But we talk about what do we want parenting to look like, what do we want custody to look like, and that's legal and physical custody, explaining to them what those mean, just like we talked about earlier. And then talking about this 25% that is presumed to the other parent. Is there neglect, abuse, mistreatment, maltreatment happening in the home that would change that 25%? We talk about what the other party might do. Do they think that they want full custody, or are they kind of in agreement? What is each party's work schedule look like? How much can you actually sit down and have kids with you versus are you in seasonal work trucking where you're out for 6 months of the year? So a lot of different things kind of wrap up into what it means to have parenting time in custody. And I think in this sense, it's more so talking about that parenting time.
Yeah.
So after I sit down with the client, whether we're writing up a petition or answering a petition, I typically send a proposal to opposing counsel. So in this case, if mom was my client and dad was Scott's client, I would send over what I would consider a settlement proposal. We would propose a schedule that works for mom that she's hoping dad will accept. Sometimes it resolves right then and there. The other party says, yeah, I'm in agreement with this. And oftentimes they say no. Mm-hmm. So then it's just working with the other attorney. And typically we're ending up in mediation to really have a conversation with a neutral party about what our outcomes would look like if we went to trial. Most of our family law resolves in mediation where we can get things sorted out. Having a neutral person kind of sit down with the parties and say the judge isn't likely going to grant that, or you have a strong case for this, it's helpful for our clients to know. So I would say the majority of my stuff will end up in mediation. But we do get those lucky off chances where the attorneys work well together and the clients are in agreement with a lot of things. And it may be what I often see is dad saying, yeah, I want them every other weekend, and mom saying, I want them Monday through Friday, but dad says, I still want them on Wednesday or Friday night, whatever that is. So sometimes we're a lot closer than we think we are to resolving parenting time or custody disputes. But in my general sense, I'll sit down with the client and kind of get a full picture before we work up a settlement proposal to opposing counsel, or to, if they don't have counsel, just to the other party.
Well, and I think that you gave some good advice earlier, too, when you talked about how you sort of try to look at it objectively and with the facts and try, even though I know it's very difficult for people to try to not be as emotional about it and just focus on the kids in that situation. So
one thing that I heard from an attorney when I started in family law 4 months ago, we were talking about coming out of prosecution, and he said, practicing family law is different than prosecuting, because in prosecution, you get the worst client on their best day, meaning they're going to act their best in court and they're going to let the judge know everything that they're doing well and why they should be released or why they should get a certain deal. And on the flip side of that, you get the best clients on their worst day. They're going through a divorce, or they're dealing with child custody matters, which are just, it's close to the heart. It's emotional.
Yeah.
And I think that's honestly the importance of having an attorney, is somebody that can kind of sit down with you and not necessarily hold your hand, but walk with you through the process. And I've gained a lot of friends out of working family law.
I bet you have.
Yeah. And it's nice to know that you have somebody in your corner.
Mm-hmm. Absolutely. Well, this has just been extremely informative.
Yeah.
I have learned a ton today, and I know that those people that submitted these questions are going to be appreciative of your responses. And so if someone would want to get a hold of you, Scott, how would they do, or start looking into what you do at Berry Law?
Yeah, they can go to our website, berrylawoffices.com, or give us a call at 763-389-0178 here in Princeton, and schedule a meeting. Our initial consults are free. There's no obligation, and we do a lot of those where we sit down and talk and just have a conversation with their, what do they want to, what is their goal?
Right.
And where do we go from here, that type of thing.
Perfect. And Miranda, how about you?
Sapientialawgroup.com, I think, is our website address. We're calling our Cambridge office 763-552-7777. I don't do free consults, unfortunately. So we do have a $300 consult fee. For listeners of this podcast, though, if you say that you're referred from the podcast, I'll set up a free consult for you. So.
Ooh, thank you. Yeah, call. Yeah, call today.
And we will definitely put that information in the comments as well.
Yep,
so
that'll be
people can
listed
easily have
there.
it. And we'll look up that website to make sure.
Thank you.
Put the link there. So perfect.
Yeah.
All right. Well, thanks again for being here today. We really appreciate it. And until next time, this is Kim and Mary signing off. This is Princeton. Stay here, play here.